Get ready for the dictation. Start. The members of the selection board, or for that matter, any other selection committee, do not have the jurisdiction to lay down the criteria for selection unless they are authorized specifically in that regard by the rules made under Article 309. It is basically the function of the rule making authority to provide the basis for selection. We are now only left with the reasoning of the tribunal that there is no justification for the continuance of the old rule and for personnel belonging to other zones being transferred on promotion to offices in other zones. In drawing such conclusion, the tribunal has travelled beyond the limits of its jurisdiction. We need only point out that the mode of recruitment and the category from which the recruitment to a service should be made are all matters which are exclusively within the domain to the executive. It is not for judicial bodies to sit in judgment over the wisdom of the executive in choosing the mode of recruitment of the categories from which the recruitment should be made, as they are matters of policy decision falling exclusively within the purview of the executive. Dealing with the question of a higher or superior qualification being liable to be viewed as being in compliance with the essential qualifications prescribed under the relevant rules, Sri Nandan firstly drew the attention of the court to the judgment of the Supreme Court in Chandrakala Trivedi versus State of Rajasthan and other, which, interpreting the word equivalent, held thus: the word equivalent must be given a reasonable meaning. By using the expression equivalent, one means that there are some degrees of flexibility or adjustment which do not lower the stated requirement. There has to be some difference between what is equivalent and what is exact. Apart from that, after a person is provisionally selected, a certain degree of reasonable expectation of the selection being continued also comes into existence. Sri Nandan then placed reliance upon the judgment of the Supreme Court in Parvez Ahmad Pari versus State of Jammu and Kashmir and others, and more particularly paragraphs 15 and 16 of the report, which are extracted hereunder. In our considered view, firstly, if there was any ambiguity or vagueness noticed in prescribing the qualification in the advertisement, then it should have been clarified by the authority concerned in the advertisement itself. Secondly, if it was not clarified, then benefits should have been given to the candidate rather than to the respondents. Thirdly, even assuming that there was no ambiguity or oblique and any vagueness, yet we find that the appellant was admittedly having VSc degree with forestry as one of the major subjects in his graduation, and further he was also having master's degree in forestry, that is MSc forestry. In the light of these facts, we are of the view that the appellant was possessed of the prescribed qualification to apply for the post in question, and his application could not have been rejected, treating him to be an ineligible candidate for not possessing prescribed qualification. In our view, if a candidate has done BSc in forestry as one of the major subjects and has also done masters in the forestry, that is MSc Forestry, then in the absence of any clarification on such issue, the candidate possessing such higher qualification has to be held to possess the required qualification to apply for the post. In fact, acquiring higher qualification in the prescribed subject, that is forestry, was sufficient to hold that the appellant had possessed the prescribed qualification. It was coupled with the fact that forestry was one of the appellant's major subjects in graduation, due to which he was able to do his master's in forestry. Reliance was placed by learned senior counsel also on the decision of the Supreme Court in state of Uttarakhand and others versus Deep Chand Tiwari and another to submit that the candidature of a candidate possessing a higher qualification cannot be rejected on that basis. Reliance was placed on the following observations as made by the court in that decision. We are conscious of the principle that when particular qualifications are prescribed for a post, the candidature of a candidate possessing higher qualification cannot be rejected on that basis. No doubt, normal rule would be that candidate with higher qualification is deemed to fulfill the lower qualification prescribed for a post, but that higher qualification has to be in the same channel. Further, this rule will be subject to an exception where the prescription of a particular qualification is found to be relevant for discharging the functions of that post, and at the same time the government is able to demonstrate that for want of said qualification a candidate may not be suitable for the post even if he possesses a better qualification, but that better qualification has no relevance with the functions attached with the post stop.